See, listen to that.
Right, I'm gonna leave the participants and share the screen. Start it up. So, there we go. Well, thank you for having us here at the AFP meeting. Always fun to talk about ethics, and you can't see all of the people in the room on the camera, but there's about 100 people on the sides. So
Yeah, right.
And so, yeah, I'm Tom Griffith. I'm the Vice President of Development here at the Central New York Community Foundation. And I am blessed to have my favorite co-presenter with me today, Christine Woodcock Dettor. And I will let her introduce herself.
Sure. Well, thanks for having me, everybody. I am a lawyer. I'm a trust and estates lawyer primarily, among my other talents. I also do a lot of work with not-for-profit organizations, from forming to advising to New York State Attorney General matters, to IRS matters, to donor restrictions, to what do I do with this fund? Like anything that has to do with charitable organizations. I started doing that work because I represented many donors who wanted to make charitable gifts. And so it just logically continues, and I'm thrilled to be here. I served on the board of the Community Foundation for a long time. And Tom and I always have a lot of fun together at these presentations. And at this point of the game, we're like Kelly and Seacrest. You know, they don't even practice. They just get out there and they just start talking. So
It just happens.
so we have a lot of fun doing this. So I try and not make things boring, especially when it's ethics.
We also try to hit the same topics again and again. So we get really
We have a thing going here, so.
awesome.
Good.
So codes of ethics, pretty much every single type of designation has a code of ethics out there, and they cover all the things like the competency you have to have, the continuing education you have to have, the sort of recognition of your scope or your limitations in your role, the concept of conflicts of interest, the concept of sort of familiarity and other types of blurred lines and things like that that might be affecting your objectivity and fairness. This particular presentation was from Conrad Teitel to the National Association of Charitable Gift Planners. This is their previous name, because this was a while back, and I think they've gone through 2 names since
Yeah,
then.
he's a funny guy. He's a great speaker. He's a lawyer.
Yeah, he's a great speaker, and yeah, this one, you know, has as appendices a whole bunch of different organizations' codes of ethics. So
Lawyers have codes of ethics. It's called the Code of Professional Responsibility. And as part of the bar exam, there's this, you have to take the exam. So it's part of it. It's a whole morass of unfun stuff to have to learn. So
but really, a lot of the why behind a code is just the concept of power. You know, on the one side, as planners for donors, we have knowledge, we have power in that regard. You know, on the other side, donors have, you know, influence, and sometimes they can, you know, abuse that too. So there's ethical dilemmas that come up on both sides of that equation, and it's really helpful to remind us of sort of those core values that are important: integrity, honor, fairness, those things listed there, and remind ourselves that our role is to be impartial, objective, and complete, really, when we think about how we're advising them. You know, it is all about them. It is ultimately their gift, and we are just helping make that happen for our organizations that we care about. Questions on that before we move on?
starting to craft the title of our revised, more exciting ethical presentation. Like ethical, I like the ethical and donor dilemmas.
Mhm.
Oh, yeah, that's a good one.
You got to use the word ethics if we're going to get ethics credit.
Mhm.
I don't think so.
No,
Not
not for the CAP program.
I don't know about CAP, but for the FRA, I don't think so.
Oh.
But that sounds good. It
Ethical.
could be like, let's be unethical.
I like that. Yeah, you could put in parentheses.
Unethical
un-
question mark?
Yeah,
Come tell your story.
yeah, all right, exactly.
Everyone shares a story.
That's awesome.
What's your latest dilemma?
So when you think about gift planners, again, we just sort of mentioned some of these things. I have a kind of funny story about compensation. I think it was Monica Moranti's mom who asked a question about like, what percentage do you get of the gifts that come in each year? Like she was paid on commission.
Oh, gotcha. Oh,
And-
okay.
And that was the question when she was hired, it was like, I think it was when she was hired at Lemoyne, actually, not here, but it was still, what percentage do you get? No, that's not how it works, Mom. So reasonable compensation is a piece. Always remembering to include advisors when you're doing these kinds of interactions. Okay.
Oh, great. When we have trick or treaters in our neighborhood, we got one,
Hi, Sarah. So we're just in the beginning slide here. So we're talking about the different roles ethically that or the different sort of pieces that impact gift planners from an ethics perspective. Competence and professionalism, boundary setting is really important. I was just at the National Association of Charitable Gift Planners Conference a week and a half ago, and out in Reno, which if that place is on
good.
your bucket list, should not be on your bucket list.
Don't
but,
go back to Reno.
No,
Okay.
it's a great airport to get to Lake Tahoe from, but I'm not sure. It was a great place to have a conference, though. The facility was amazing at that casino hotel. But anyway, but one of the things that came up in a discussion was just the boundary lines. I mean, like fundraisers from a university that had been proposed to or asked out on dates by, or asked if they could be included in the will. I mean, like literal boundary lines around like relationship being treated almost like family and friend versus a professional friendly kind of relationship that is appropriate. So you have a story to tell there.
I was asked on a date.
Oh, that's kind of fun.
Mhm.
So in our office, my HR director taught me something a long time ago when interviewing staff or paralegals, everything. And she said, you want to be friendly, but not familiar. And you always feel when somebody crosses that line, and there you got to double back and never go by yourself to that person again, right? Lots of different counterbalance measures, but you want to be friendly, not familiar. And you got to make sure you follow.
She coaches me a lot.
Oh, good. Oh,
She does a really good job at it. I'm an engager and it's hard.
yeah.
She engages too much.
Got it. Friendly, but not familiar.
Yeah, I remember that.
That invites more familiar behavior, then you might get yourself in trouble with that.
Mhm.
It's great advice.
And definitely had donors offer things to me as part of their estate, and I'm like, no, thank you. Cannot accept that. Totally understand why you might want to give that and appreciate that, but
Eggs.
with that,
With the Sankey eggs. When we visited a donor couple and
Oh, yeah.
they were Hungarian, and so they had this tradition of doing these hand decorated eggs around Easter and very delicate and like treasured like family memorabilia, and so like they wanted to offer us one, and we
Had a collection in their living room.
thank you,
Wow.
very generous, but we
Right, and they were beautiful,
Yeah.
I would love to have one, but it's.
Take offense to that. It's,
well, I know,
it's-
We were very respectful.
Yeah.
Oh, yeah, wow, I really understood, but.
Yeah.
sometimes you just can use your institution as the, my work doesn't allow me to do that, even regardless of whether there's actually a rule like that, but that's definitely a way to protect your relationship without.
Yeah, it's a good prelude to, some of the things we're gonna talk about in a minute, which is capacity. Like, do your donors have all their marbles? That's important to know what your what that person's capacity might be. This is not the presentation for everybody getting into trouble. We do that presentation too, but when donors do give eggs and then they pass away, or they do give, large bequests to charitable organizations, sometimes their children don't think that that's what they really would have wanted to do had they had full capacity, right? And that's when the lawyers get involved and challenge that gift and try and bust it up. And that's when the Attorney General gets involved. And now he's even closer than he ever was. He's at the One Park Place building. Used to be out on Erie Boulevard for a good long mile, but the Attorney General is in charge of not just regulating charities, but getting involved when a donor dies and leaves a will or a trust and has directed some kind of disposition to a charitable organization. So you gotta follow these best practices to not get into big trouble later.
And that last item on the slide of public trust too, I mean, you are a representative of a nonprofit public charity. And, I like to think about that word public too, like, is this something that I would like to have be covered by the news? So that's the kind of the mentality you really need to have around, is this something that would be, if publicized, well received. So that's sort of the standard I like to use there, but so I think I'm missing slides here. All about them. This is going so fast. Okay. Confidentiality. That's a really important piece. Again, it's setting that expectation with your donors and defining for them sort of what is the use of the information that they provide. How will it be shared, whether it's internally, externally, and getting like actual written documentation in cases where you're wanting to share something externally for sure. But in general, you want to be disclosing to them how their information is going to be used in all cases, especially their personal information. And you need to be following the rules about controlling that as well, so that it's not just, sitting out on desks and other things like that. Anonymity is something that they request from time to time, and it's super important to honor that religiously. And storytelling is a thing that we all love to do, but again, only if it's with the permission for the content that you're going to share in that story.
I take something that could be perceived as boring, confidentiality, and I put a little bit of a twist on it. I think about this in terms of the legal word is donative intent, right? It's the intention of the donor. What are the donor's intention? Because guess what? As a recipient charitable organization, you need to abide by that. And so, what are their restrictions? Not just use restrictions and amount, but what is their issue regarding confidentiality and anonymity? I mean, many of the greatest stories ever told that hit the Post Standard about your millionaire neighbors who were like dry cleaner owners in Binghamton give $60 million to Lemoyne, right? So maybe those people, although they wanted to be anonymous during their lifetime with whatever gift giving, and there are many of those people, they were okay after their passing to have it be public information, because a lot of this is public information, at least if it goes through the court system, if it's in a will or it's in a trust, because those are public documents.
There's ways that the attorneys can structure it so that it doesn't have to necessarily go through the public as well. So, wow. So yeah, a lot of our donors our senior citizens. That number is only growing. So that percentage of the population is growing. The
I saw an article recently, it was, that said, all of the baby boomers are gonna be 65 by something like 2030, whatever the math on that is.
Yeah.
And I was like, whoa. That means everybody who's still in the workplace has got to really, and is maybe in a Generation X state, really have to embrace these millennials, because those guys are gonna be retiring in short order. Really, they are, if they're not already.
and there's also peak mental capacity really occurs at about age 55. So I know, got a couple more years, but like it really does, like it hits that point, and that for all of us, there's some decline. And for for some of us, that decline is significant and accelerated. And the thing that I have noticed in particular too is that once somebody reaches about age 80, the years after that are just very accelerated decline can occur. And it doesn't always. I mean, just with a 97-year-old that just walked like he was, a 65-year-old. So I mean, like, and his brain was great. So, it's just, you never know. But it is a significant concern, and we're actually going to touch back on that in a little bit.
Oh my goodness, a slide just for me, sort of. So capacity is great. So legal capacity. There's two types that I'm thinking of that are appropriate to mention here. Number one is the capacity to execute a will. In New York, it is very, very, very low, because public policy wants to encourage people to make a will. It's basically, you need to know about approximately what the nature of your assets is. The actual words are like, when it comes to like your people, your spouse and your children, like it says the natural objects of your bounty. Like that's actually the real word.
Natural objects of
Yeah,
your
That means your kids, your distributees, your treasures, Tom. So you have to basically know like that, right? The natural objects of your bounty.
To call my 9-year-old
Yeah,
that.
I know. You got Google that one and you'll see capacity to execute a will in New York.
I just found out.
Yeah.
Object of my bounty.
Yeah, right. And so it's basically, and you have to know basically what you're doing, like a very low threshold. If you're going to execute a trust, and that's testamentary capacity, right? Because you're executing a last will and testament. The interesting thing is if you're going to execute a gift agreement, a pledge, a trust document, those are actually a higher standard of legal capacity, because you have to have the capacity to execute into a contract, right? Because if it's a pledge, it's like, it literally is a contract, a pledge. A trust agreement is a contract, a gift agreement, a scholarship fund, or whatever fund you're going to create, a fund agreement or advice fund. It's a contract between you and the charitable organization, and you have to know more. The standard of executing a contract is a higher standard legally than the standard for executing a will. So, with a contract, you have to have an offer. Like, here's what I want to do. You have to have an acceptance. The charitable organization says, yeah, that's what I'm going to do. And you have to have basically what's called like a meeting of the minds. Mutual assent is what they call it. Like you both know what you're doing. Even if you hire like anywhere in life, the plow guy for the season or a contractor. You have to have an offer. I want you to do this. An acceptance. Yes, I'm going to do this. And we have the same understanding of what the scope is, and a meeting of the minds about how this is going to be fulfilled. So will standard is a lot lower. That's testamentary capacity than most of the stuff that you guys are going to have donors sign. It's a contract they're signing, even if it's a pledge, like an intention to do something. Signs of incapacity, different than just, I think that's on the next slide, different than signs of aging. like memory lapse, very classic is. I was gonna think, like my mother, saying the same things like 7 times in a row. It can be like this, don't let her see this. It could be like a sign of, they remember everything chapter and verse from like 1982, but that, short-term memory, right? See, look at me, Tom. I get 55, I'm already losing it. Confusion, a big one, and it's always so sad to see. And you guys who were more regularly like visiting your donors, you'll see somebody's decline. The last two, changes in personality and mood swings or inappropriate behavior, that also is a sign of, I'm not an MD, but that is a sign of cognitive decline, right? So the physicians will tell you that, like the anger part, the changes in personality, mood swings, reactionary behavior. It's almost like, I guess simplest way to describe it is that your body is experiencing cognitive decline and you're really mad about it, right? So that's part of development of cognitive incapacity.
Can I ask a question?
Yeah, please,
Like,
go ahead.
I mean, Jen, you would be dealing more with the, elderly, legacy
donors.
planning, yes, aging donors. But at what point, if there's that memory lapse, all those, the list that you fusion, all of that, at what point do you engage like the secondary person to when you're meeting with those aging donors, explain-
Second, your little spidey sense says, uh-oh, something's going on here.
Mhm.
You bring in the second person, you ask that person privately, do they have power of attorney? Part of donor relations is continuing your lovely conversations, and your potential donor may make great sense tax wise and otherwise to continue with it. You might need somebody who's their power of attorney to be able to fulfill that.
Mhm.
And more often than not, that happens organically because we're not spending a ton of time with our donors. I mean, we do see them, we contact them, but at the same time, people who see them all the time, like the family and friends, are gonna notice all those things long before we typically would, and it'll be more likely that there'll just be another person there when we come for a meeting.
And who notices more regularly are investment advisors, because monthly, daily, weekly, they're getting the calls. Accountants, quarterly estimates or tax return prep once a year. Sometimes the lawyers are the last to know because you only zoom in and revise things with your lawyer periodically. But what you'll hear from family members, you guys know this if you handle matters pertaining to aging, they'll tell me that, just so you know, mom is on a decline and she's forgetful and this, that, but literally I won't notice it because they will pull it off for you. And it's only if you're with them day in, day out that you start to notice that. So that can be a little tricky. So you have family member telling you that there are issues. I just had this one of my clients that just turned 81. And other than a little nervousness about signing documents, I did not notice any marked cognitive decline. And I do this all the time. So that's a little tricky, Parker, because sometimes your donor, if they're aging, can pull it off and you're not going to notice even with all your antennas on. But family will be telling you and whispering in your ear, just so you know, a little difficult.
Yeah, so the normal kind of things that happen with age,
Mhm.
that aren't related to capacity, but can also be impactful to the relationship. I mean, hearing and vision are big. That can be isolating, that can also cause even depression, disconnection, fine motor skills, speech.
And if your client, by the way, can't sign his or her name anymore because the kids have everything on auto pay or whatever, but they have to practice to gear up, that's or the signature sloppy. None of that matters. I've even had clients who can only make an X because of some physical disability. And I've even had clients who can't make an X, and there are provisions in the law. To have, Tom, I hereby authorize Tom sign that on my behalf. So don't worry about the physical act of looking at a beautiful signature. There are lots of ways to be able to get something signed.
Yeah, maybe I'm surprised it took this many slides to get to make the statement that contemporaneous written documentation is important for anytime you're dealing with anyone as a donor, but especially when you're dealing with, cases of, aging donors. That is extremely important that you come back and you write down and you talk about, we had to do this differently because they are having this problem, so noting those kinds of things, which you might feel at the time is a little too personal, but it is instructive to the relationship and knowing that you were aware of their capacity or issues going on at that point. So yeah, when you think about sort of leaving the aging part and just thinking about relationships and boundaries again, especially with the donors that are ongoing relationships, it's super important to establish that good baseline, to listen, to understand. Again, it's all about them. We at the Community Foundation try to, especially for important discernment conversations, have two of us there. Two sets of ears is better than one. But it's also, helpful to bring a colleague from time to time as well, just to change that mix up as well. And they may notice things that are, boundary issues and other things like that that may be getting close to the line. The timing and location appointments, that's also an all about them kind of thing. And we want it to be, easy for them and that kind of, so where and what time, but at the same time, we also don't want to be violating boundaries, so in the house might be okay, but it just sort of depends,
Yeah, I do that all the time, thinking about, okay, my office where they're not distracted, house visit if that's easier for them, more comfortable. But timing, I don't meet with many seniors at 8 o'clock in the morning or 4 o'clock in the afternoon. It's usually like a solid 10 or 11 or 1 or a 2, because 4:30 at 5 o'clock is not the best time of day. And I think established, at least I hear about it often, that the older you get, the less sleep you're not able to have as restful a night's sleep, put it that way. So in any event, timing and location of appointments is really important.
takes them longer to wake up and they definitely get tired by the end of the day. Yep. And so as with all donors, this is especially true for older donors too, but you need to be clear about why you're coming to visit them. What is the purpose of this visit? Working on that time aspect as well, and respecting that time. I know sometimes it feels like you want that conversation to be free to go where it goes, but at the same time, that's a difficult boundary then, because then that can lead to all kinds of things if you don't say, I'm going to be here for half an hour, I'm going to be here for an hour. And, if that bleeds over a little bit, that's fine. But if it ends up becoming an all afternoon, affair at the house, and, it's just,
And
again,
no
back to
cocktails.
balance. And no,
No cocktails.
I mean,
But don't let it go into cocktail hour, and don't take one and don't let them have one. Bad.
Lynn's like, I don't know about that.
Comment.
To the best of my recollection, I don't recall.
If anybody at the food bank, they say I do my best fundraising in a bar.
But that's a little different because that's broad, not client specific fundraising. That's more social education, awareness.
You can have a donor event
Yeah, right.
versus the whole one-on-one time. All right, so always being prepared. You want to go in there being able to expect questions, have the answers to questions. And from your perspective as a fundraiser, you want to have a goal around the visit. Like, really, what are we progressing this donor through? What is the intention? What are we getting them to? And sometimes there's going to be an ask in there. Sometimes it's just going to be an exploratory conversation about what's important to them. Sometimes it's, connecting about an event and leveraging relationships. I mean, who knows exactly? Sometimes it's getting a status of, why they haven't gone and signed their documents with their estate planning attorney that's asked them to do that for
Right, 6 times.
So,
Yeah, and the thing about be prepared, but be ready to answer questions. A lot of my younger lawyers, they get so nervous that they don't think they can answer all the questions, or maybe people who are new to development, or they haven't met. You don't have to have all the answers. One of the magic things as you get older is you actually have fewer and fewer answers, but you know where to go to get the answers and then get back to your potential donor or client. So
yeah, they're just as happy with that responsiveness too. But again, that whole truthful response of, I don't know, but I can get back to you. Always good. Again, just revisiting that it's all about them, being respectful of time, thanking them for their time, regardless of whether they do anything there. Documenting, again, your meeting in detailed notes when you get back from the meeting. Again, thanking them, whether it's with an email or a note or a text. There's so many different ways that we can communicate now. That is an important step too. And then what's the next step? And again, when if some issue were to come up and there was some sort of lawsuit and you were going to have to disclose all of your relationship notes with a particular person, it makes a lot more it appears to be much more understandable if there's actual progression to and a plan attached to it, as opposed to, why were you just hanging out with this person for 3 hours every Friday afternoon at the Nottingham? I mean, like, that thing is just really, it's important that there be a distinction there, because that does not look great if you were to think about, again, what would the public say? What would the media say? What would
friendly, but
a
not
judge say?
familiar.
So yeah, avoiding allegations.
Sometimes you can't avoid allegations. It's just like sometimes you can't avoid, sometimes family members are a little nutty, and what's going to happen is going to happen. But how you can protect yourself, right? It's really what we got up here. Not every visit will culminate with a formal signed gift agreement. Tom, what do you mean when you say make written disclosures? Like about like a fee schedule for the community foundation, for
Right.
example?
For example, like when we go and talk to a prospective donor, we leave them a packet of information that describes all the things that we talked about. Like, here's the fund and the information about the fund type that we talked about. Here's how we do our investment management that we talked about. Here's our support fee schedule. Here's, so here's our annual report, so those kinds of disclosures and documentation are important, for, depending, for other types of advisors, there may be additional disclosures that are required based on, their designations and things like that. But for just the typical fundraiser, that's the kind of disclosure I'm talking about there, is, leaving them something in writing. And the reason for that too is when their daughter or their son or their friend asks them, well, who was that car in your driveway? Why were they there for 2 hours? And they say, oh, it was this person from the community foundation. And, for them to be able to not just try to recollect some of the things that were talked about, to be able to actually share something, that actually puts a little bit more confidence in that person's, heart and mind as well, that oh, maybe this is a reasonable relationship for this person to have. People are protective of their friends and their neighbors, and that's just,
Obviously, gift acknowledgement letters, when the gift is completed, is required by law. And the thing, unless it's like an annual gift or it's not a high dollar gift, if it's a planned gift, which of course is a whole other seminar that we do, I think, we do that one.
Yep.
You want to involve the accountant because you're gonna get a charitable deduction and it could be carried forward for up to 5 years. You want to know what the limitation or the advisability of that is, or whatever the gift is, it's a gift of appreciated security. So you want to involve the tax accountant and the lawyer, if it makes sense, because sometimes lawyers have to craft a gift agreement or review a gift agreement. And family too. If it's a cohesive family, sometimes bringing in, the daughter or the son who's going to be the executor and who is the power of attorney is a pretty darn good idea. The other thing I've found is probably just human nature. Sometimes we come in and if they're an older person, they don't necessarily, they don't know the processing time on what to make of me or Tom or any of us is a little slower. But then when their son or daughter says something or reiterates what we had just said, they're like, oh, okay, I got it. Because they're so in tune to that person's voice and explanation on things. So that's a good trick, good strategy.
helps down the road too.
Oh, yeah.
This is all you.
This is great fun. So undue influence, will contests, objections to trust. So it's an art and it's not a science, this area of trust and estate litigation. Facts matter, and some of the more outrageous the facts make very interesting cases one way or another. So, for example, we talked earlier about testamentary capacity, right? What you have to know and understand. You have to know all 15 pages and every line in your will to be able to execute a will and make sure it's valid. No, but somebody who is a beneficiary or would have been a beneficiary if not for the charitable bequest may have an opportunity to object to the will or challenge a provision in a trust. So the art part, like law TV, right? You have to show by a preponderance of the credible evidence. So take that one apart. Credible evidence. Preponderance is kind of like more often than not. It's not clear and convincing. It's not like, criminal trials. And when they say usually circumstantial, I don't know, maybe I said that, usually circumstantial or not direct evidence, that means that's where the facts come in, right? Like there's a slide after this where some of the more regular mishaps and misdeeds, those sets of facts give rise to this. But usually circumstantial, there's never a direct smoking gun, especially if your person is deceased. Usually it's like adding up all of the things that kind of were funny or went wrong and making the case that way. Because remember, preponderance of the evidence. So this is a hit list of what not to do. So in your particular set of facts, your testator, that's for a will, grantor, settler, creator, all those can be the person who creates a trust. If their physical and mental condition, especially mental rather, is on the decline and some intervening thing occurs, that's a problem. One of the things that you see regularly with bad actors is they take the client away from their longtime lawyer or tax accountant or advisor. And they either bring that person to their attorney or to some, shady character that they found in the yellow pages. If there's a marked change in what the prior will may have said, that can be a problem. And even if you're successful in your big legal endeavor to get the current will upended, you want to know what happens if you get that one overturned? goes right back to the prior will. So know that the testamentary pattern matters. So people who wield undue influence, were they in a position of trust? Typically, all these cases where something really bad happens is, much older person, much younger caregiver, paramour, something along those lines. Like that thing is, one of my litigators, one of my partners always tells me, just because somebody's in a position to exert and exercise influence doesn't mean it's necessarily undue. So just because you're influencing a person to, I don't know, set up a new giving plan, doesn't necessarily mean it's bad. Right? So you can exercise influence, and most of us do as daughters and people who are in a fiduciary position. But it's not always bad, and you're not always going to win on this. In fact, it's very, very hard. Sometimes people come to town and they start to isolate your donor from their children and family. That's bad. So there's a whole list of cases and facts and, cases that are brought in court are public. Most of the time they get settled, and settlements are confidential. They're not usually filed with the court. So you never really do know. It's only the anomaly when somebody brings a case, doesn't have the presence of mind or can't manage their client to actually settle the case, because going to court is not fun. It's very costly. Usually, one of the judges I used to work with would always tell me, it's a good settlement if both sides are equally unhappy, right? So you're like, I'm unhappy, but I can live with it. I'm unhappy, but I can live with it. Good settlement. Not always in the court. It's the only time that all the industrious law students and young lawyers of the world get to research the daylights about all of these cases are the most crazy and the most egregious cases, because then the judge has to decide, which you think if you're a judge, you would be able to decide and write up your opinion or have your law clerk write it on up. But a lot of times they're really reluctant to do that. And then there's an appeal if you don't agree with the decision or it's not in your favor. But so to get all this exciting case law, it's almost like the worst of the worst, so that's how the body of law evolves. But it's not usually easy. Like I will do everything I can possibly do to try and avoid a client just because they're super mad that mom gave, half the money to charity. I was like, tough on you. That's anyhow.
Yeah, well, and there's an example where we were one of 4 charities that was the beneficiary of donor's will, and donor had new caregivers come in to the situation, and when the donor passed away, all 4 charities knew that we were in the will and wasn't in the will. So the will had been rewritten and was being sent to the 2 caregivers, which happened to be a couple. And so
Just happened to be, huh?
so yeah,
New
so
lawyer,
new lawyer,
isolated from children. and
isolated
family?
from children and family. And the interesting part there,
Any physical, mental.
right? So
material.
all these factors were present, right? And we couldn't win, but the Attorney General was able to get them to agree to a settlement where I think about 1/3 of the assets got split then between the 4 charities, and the remaining 2/3 still went to the caregivers, which, so I mean, talk about difficult standard.
Yeah,
So
there's really never, ever, it's so like, shady. There's never any like real smoking gun usually.
weren't they considering a change to the estate and trust law to make it be presumptive that caregivers
I don't know that.
being beneficiary? I thought that there was something that was proposed, but anyway, we digress.
You guys have to go in like 3 short minutes. We have like we're almost at the end. We just have 2 quick comments.
The last slide I'll just do now. So elder abuse is a really totally different topic or adjacent topic, but Onondaga County Adult Protective Services is available to help if you think that your donor relationship is under, elder abuse. And the phone number and website.
Somebody else, like usually it's the kid, by the way, just so you know, like, and it's like, it's always the spouse or the boyfriend it's always the kid in elder abuse situations or a caregiver, but many people are familiar with child protective, right? There is a corollary division of DSS, and there are adult protective caseworkers who specialize in adult protective services, just like child protective services.
So we'll go back one slide and just talk, whoops. And make the mouse thing work. There we go. We'll go back to case studies. So, you guys can leave whenever you need to, and I hope your laptop's not on fire. So,
This laptop gets so hot, it's
Oh, wow.
ridiculous. So I was just like trying to get some air underneath it to cool it down. When I went like that, I was like.
no, I knew something was wrong because you
Yeah.
were like, wow.
No,
so
it gets hot at my
you were
desk
feeling the
too.
table, yeah.
I'm hoping, and I have to have it plugged in, because if I'm not docked, the battery
Battery
can.
can backed up someplace in case it all of a sudden goes.
So I'm hoping that, I get
Laptop.
new laptops from IT. It might be on the list.
Gotcha.
I'll fundraise for it. Thank you, guys. Sorry. we had-
Fundraise for it.
No, I mean, we're.
Pretty much, yeah. We were
Yeah.
just probably can talk through some of these case studies or answer any
Friendly,
questions.
Exciting for you. Lovely. Okay, tell all your friends, it's not that boring.
Friends with us.
You two seem like people who would have a lot of friends.
We might.
Mostly Heidi, but yes.
Yeah, definitely not me.
Yeah.
I don't know anybody.
Well, and Tom, do we, remind me on this, especially for Sarah with us and,
Mhm.
do we have specifics for all this, or does it speak for itself? Sure.
Well, I already gave the case study that in the fourth bullet there around caregivers
Your team.
becoming the primary.
Right, oh, gotcha.
But,
I don't know.
do you have any good family challenges of intent or
No, but I would say the first two. Substance abuse, it's such a tricky little adversary. Sometimes many times you wouldn't know it. Or they can get through an hour and a half or whatnot, and you wouldn't really know it. Unless you have it seems like unless you have personal experience with someone with drug or alcohol, mental health type issues and substance abuse. That's a really hard one, unless there's again, facts, right? Unless there's a pattern of behavior over a period of time that's so obvious and outrageous. That's when substance abuse comes in. Signs of dementia. That's tricky too, but just because you have a diagnosis of X it does not necessarily prohibit like executing a will, or if it makes sense for tax purposes, giving a gift to charity or regular annual gifts to charity. Professional advisor interference,
Yeah, I've literally had financial advisors trying to steer their clients to use to give their charitable piece of their plan to nonprofits that the advisor cared about.
oh geez,
Oh, wow.
yeah,
Yeah, like they're involved with an organization and
See that? Yeah.
the person, the clients, it doesn't matter if they're interested in that or not, they're pushing that person to include them as
really?
part of the charitable.
Well, you are in a position to exert influence, right?
Mhm.
But is it undue influence? Not necessarily. It's even like, I've had many clients who have this idea about a scholarship fund in honor of a member of their family, or at least a restricted use. And they have no idea what the community foundation is. And we hear all these things like, oh, my number one goal is so that people remember my daughter. My second goal is, to support very unusual cancer research. I mean, and like, what am I gonna do? Send them over to Upstate Cancer Center? They're not, that's, part of what they do, but all signs scream community foundation, community foundation, community foundation. Are you going to be giving money during your lifetime or at your death? What's the, do you want to create the story if keeping your daughter's memory alive is critically important to you, which I can imagine it is. All of it. And so, but you have to be careful. And that's when I have to like step back and many times there are these, like the state planning council is always, or the articles that you guys write, like, it's kind of a funny thing, but it's like popping the question. It's not, will you marry me? It's, are you interested in the community foundation, right? It's when you're an advisor, bringing up the subject of charitable giving, however it comes up, hearing the story of a tragedy, looking at the size of somebody's estate, looking at their tax implications and thinking how much they could be saving if they're making a donation. You have to, I think it's almost like it's professional malpractice to not bring up the subject. But certain advisors are so nervous or proprietary or whatever that they just don't go there. They have to have the client come and say, well, I'm very interested in my church and I'm very interested in dog rescues and that's the way it comes up. But, interference, the influence would be a better word for our new sexier presentation. Like, because I do feel like I do a lot of interference, but I don't know if I exert influence, So I don't think I'm doing my job unless I'm brave enough and astute enough to bring up the subject. And then I have to like step back. Once I've got the connection with you guys and Tom, then I got to step back as the professional advisor and allow that relationship to gel. And it's very interesting, when you're in a room with your client, I'm doing a lot of listening, but then I'm processing what are they saying based on what I think we need to do, what the plan may be. In many instances, you guys have the luxury of just like listening. And it doesn't matter what age you are. People light up when they talk about something that someone they love, something that interests them. And the listening part is really a super long front loaded part of the conversation. And all the while you're thinking, right?
Yeah, and I'll just add on the last one about family challenges. We actually have an estate. It's a large gift. We're not the only charitable beneficiary, but the primary beneficiaries of the estate are charities, and 23 family members. These people didn't have kids of their own. So these are all nieces and nephews and brothers and sisters and that kind of thing. 22 of the 23 noticed family members on the notice of probate identified that they're planning to challenge the will. So, probably mostly because they didn't know that their rich aunt and uncle were leaving their money to charity. And probably had discussions with their rich aunt and uncle from time to time that made them think that they were going to get something from this estate.
Can I just tell you, if I could put out an APB to all nieces and nephews, unless they, 'cause it happens in my office, unless they show some sort of mutual interest or attention to the couple, routinely they get written out. Oh, I haven't heard from so-and-so in such a long time. Whoosh, you're out. I mean, they routinely, that is like the number one, a couple who did not have children or grandchildren. And they instead would rather have their money go to charity, but who would have stood to inherit are the children of their siblings. Those people are disposable in many instances. They think they're the takers, the next logical takers, but they have absolutely, not even children have the right to actually inherit under New York law. And so these nieces and nephews, if they don't pay good attention to the older aunt or uncle, they're regularly out. Well, you know.
Well, at this point, I guess we'll just say thank you, and it was great to be with the group today and be able to chat a little bit about what might be considered boring by some, but I think Christine and I find exciting
Trying
and
to make it very exciting for everyone.
Call it ethical and donor dilemma next time.
I like that.
I must stop the.
And
Ethical and donor dilemmas in gift planning. That could be good.
if you don't mind sharing